Welcome to the Kemp IT Law IT Plus vlog. I'm Richard Kemp, and this vlog is the second of two about data sovereignty and looks at what the new UK Investigatory Powers Bill currently going through Parliament will mean for business. The start point from the business perspective is a pragmatic approach to understanding that data sovereignty is really about risk management. The surveillance powers of the state that we're talking about have always been there, and to an extent always will. And it's not just the USA and the UK that have these laws, most countries do. This means that cloud service providers, and so their customers, are potentially subject to data collection and interception under the laws of, first, the country where they're headquartered, secondly, each country where their data centres are located, thirdly, any country claiming extraterritorial powers, the right to intervene beyond its borders, fourthly, any country imposing national data domiciliation requirements, like Russia, for example, where since September 2015, personal data collected in Russia has had to be stored on servers located in Russia. All this makes for a confusing picture, but on the basis of this pragmatic approach, 5 changes to the current UK investigatory powers legal framework would see significant improvements and increased trust at this time of huge growth in cloud computing. First, the new statute should expressly recognise legal privilege. That's the protection from disclosure of information communicated in the doctor-patient, the lawyer-client, and the journalist-source relationship, something which didn't figure anywhere in the UK framework before last year. Second, the need for a higher level of judicial involvement in issuing the warrants that allow the security services to intercept and access data and communications. Third, cloud providers should be enabled to be more transparent about their interactions with state agencies. Fourth, international cooperation between national agencies needs to be improved. The current system takes 10 months to process a request for emails, far too long for fast-moving cyber investigations. Lastly, and perhaps the most important point of all, is to bake into the new law the fundamental safeguards that the European Court of Justice has said in its recent judgments are so crucial. If you'd like to find out more about data sovereignty, check out our blogs, vlogs and white papers on this hot topic at kempitlaw.com.